Hey everybody, it's Skye Schooley here, staff writer with business.com. And today I'm talking about the executive order that President Biden signed on July 9th of this year regarding non-competes. Now, the executive order is encouraging the Federal Trade Commission, also known as the FTC, to curtail the use of unfair non-compete clauses or other clauses that might limit worker mobility. To gain some expert insight on this topic today, I'm joined by Andrew Zelman. He is a labor and employment attorney and a partner with Berger Singerman. So Andrew, as you know, today we're talking about Biden's recent executive order regarding non-compete agreements. Given your legal expertise and thoughts, how might the FTC enforce Biden's recent executive order? For example, are we expecting an outright ban of non-competes, or is it some sort of limitation that we should be looking for?
It's a good question, and it's a difficult question to answer because the answer is not necessarily found directly in the executive order, nor is it found in the fact sheet that the White House promulgated right around the time on July 9th when the executive order came out, nor is it really stated in President Biden's statements. We know that President Biden has an agenda, or has long had a goal to curtail some issues involving competition. And that's really the genesis of where this executive order came out. Now, what's important to note is that if you read the text of the executive order, it's not on its face changing the law. There's no change of law starting today or starting on the date of the executive order. What it's doing is and the wording is encouraging. It's encouraging the FTC to exercise its statutory rulemaking authority to regulate restrictive covenants. And now, this is not the first time that we've seen an executive order of late where the president has raised this issue and brought this issue up to the agencies. We know in 2016, President Obama, came out with an executive order towards the middle of the year, where he asked for a call to arms or call to action in order to curtail these same issues that he complained about. Now, the focus of President Obama's call to action was for these agencies to scrutinize the different states and how they were applying the restrictive covenants. And really, the focus was more on how it's affecting the mobility of lower wage employees. And I think that's important here because when we read the executive order, it really doesn't limit it. It doesn't limit where the FTC is supposed to look and where they're supposed to go with their rulemaking authority. But I think we can read into the wording that there's probably a likelihood that it's going to focus on mobility of certain classes of employees, certain levels of employees. For example, hourly employees, non-exempt hourly employees may be included in that. Another important point with the executive order that I think sort of answers part of your question is that it's likely not limited to just non-competes. The actual language in the executive order states essentially that it's non-competes and other clauses or agreements that may unfairly limit worker mobility. So I know I've said the word mobility a few times. That seems to be the goal here. We don't want to restrict employees. There needs to be changes to some of the laws. We are encouraging the FTC to get involved, exercise its rulemaking authority. So what other types of agreements could there be? There could be non-solicitation, could be non-disclosure agreements. And these are all part and parcel to your typical package of employee agreements that management or an employer may, depending on the state, depending on what's allowed and what's considered reasonable in the state, if there are restrictions, would consider enforcing on employees. Otherwise, there is a little bit of a conflict between, as I mentioned earlier, the fact sheet that the White House published right around the time the executive order and the press release, because the fact sheet sort of makes it clear that we're looking to ban or limit non-compete agreements, which I think is sort of what the rhetoric is. It's either a banning or a limitation. And I would say it's probably going to be more of a limitation if any kind of action goes forward. But the executive order actually softens that language or that statement because the executive order focuses more on the unfair use of non-compete clauses, including clauses or agreements that may unfairly limit worker mobility, as I said before.
Awesome. That was very insightful. I think you actually had touched on some of my questions that I was going to ask, but we can go through those anyway.
Sure.
I was going to ask, what legal challenges might businesses face once this order is implemented in some capacity?
Right. And so, the FTC has rulemaking authority. We know there's going to be some challenges to that, depending upon what exactly they come out with, that they actually try and legislate here. But I think in terms of if there is hypothetically a new law, or there's some sort of federal law that's implemented, which expressly overrides what's in the states or preempts what's in the state law. I think you'll see a situation where there will be fines, and I think that if a company decides we have a good law here, it's a federal law, the FTC has pushed it, the bill's been signed, and the appropriate language is there. Down the line, if they don't obey, it seems to be a situation where there will be a fine. It seems to be another situation where in the civil legal world, trying to enforce a non-compete that's unenforceable is a problem, and you could potentially see there being some sort of attorney's fee provision for bringing what would amount to a frivolous lawsuit if in fact there's a law in the books that says otherwise. Now, we don't know whether the passing of any bill, how far back it's going to go, if it's going to be retroactive, if it's going to apply to the time period starting now, which is why it's sort of important for employers to be aware of what's going on. I'm glad I'm doing this with you today.
So hypothetically, if the FTC does make some implementation of this, is there any way that employers can maybe alter or look at employment contracts for new or existing employees to just make sure that they maintain legal compliance throughout?
The caveat to anything I'm about to say is that the law hasn't changed. It's still, you look at your state law and you determine based on your state whether your restricted covenants that your employees are in privity with, whether they're enforceable or not. Sometimes it's a question, you got to look at the case law. So right now there is no changes, but certainly it is important, as with every good practice of management, to look at your policies and procedures, to look at your employment contracts and look at your agreements if you have them. If it's a separate standalone agreement, I think it's important as well. Now, there is no mention in the executive order of your standard confidentiality agreements, trade secret agreements, proprietary rights agreements. Could that be considered within the rubric of this broad any other agreements that restrict employee mobility? Maybe, maybe not. I think that if there's a legitimate business interest in protecting the colonel's secret sauce, or something that is really shared with employees that needs to be maintained confidential, there are other protections you have for that. But that is the point I want to get across. If an employer wants to be proactive here, if employees are privy to restricted covenants right now, and there's a possibility, perhaps a lower level employee in terms of job duties, responsibilities, or pay, or even upper level employees, I think it's very important that if part of the legitimate business interest that you have for restricting this employee from post-employment mobility, if part of it is because you don't want customer lists being divulged, if you don't want trade secrets being outside of their hands, you don't want anti-competitive behavior from an employee, and you are trusting them because you feel that you have these restrictions in place that may go away, I think it's just very important to look at your standard operating practices as a company and make sure that that information is kept confidentially, because certainly if it's not, you may not even have the statutory protections or the contractual protections of maintaining confidential information. So I think for an employer, it's important that on their end, they're safeguarding this material and information, and then it's apparent to the employees, hey, we cannot disclose this. Sure, a customer or customer name or customer list on its own may not be anything that's proprietary, but certain laws in certain states would hold it as so, and they can't, for example, send it to their personal email or send it to a device that is not a company device. I think those things are important to refresh when it comes to company policies. With agreements in particular, if there's an existing agreement, I think it's important to look, particularly with those states where their laws have been changing. And for many states, they've been changing a couple of times a year. Certainly since 2016, there's been a rash of states that have categorized certain employees as either being immune from non-compete, restricted from actually signing one, or non-solicitation. I think it's important to keep up to date with those laws, make sure you're in compliance. And for those such as Florida, where you have a codified statute, which is not necessarily verboten, that it always works, that it always applies to every situation. I think it's important to read up and make sure that you're in compliance. Now, I've mentioned a few times today that if I were to wage on it, and certainly isn't legal advice, but looking at the pattern, looking at the comments from the president, looking at what we know from the past and what other states have done, perhaps the easiest change to any restrictive covenant would be, in terms of enforcement, to restrict it to those lower level categories of employees. And so that isn't to say that the advice would be, don't offer non-competes, non-solicited restrictive covenants when you're otherwise available to now to the lower level. But really, I would do an analysis to make sure that there really is a legitimate business reason for doing this, and it's not merely my employee is a cashier, and I don't want this employee to go across the street and work at this other store. That's not something that the FTC would, I'm guessing, would consider to be a legitimate business reason for a non-compete. Neither would most state laws as well.
So given everything that we've talked about today, is there any type of potential time frame that employers should be thinking about? Is this something they should be addressing immediately, or is the rulemaking process going to take a significant amount of time that they have some time to kind of handle this?
I think that President Biden is motivated and has certainly spoken a few times about the need to do this quickly. But at the same time, the executive order, the wording is not that strong. It's not. It's not. There's not a lot of mandatory language in the executive order, which obligates certain things to happen by a certain date. Now, obviously, the FTC is going to move. But that process can be a very lengthy process. You do have the opportunity for notice and for opportunity for others to be heard. Certainly, when you have a situation where an executive agency is attempting to potentially rewrite or curtail or preempt state laws that have been in existence for a long time, there's gonna be challenges to it. And so I think that the FTC process may take months. I think that the constitutional challenges may take longer. So, being skeptical, I would say it's going to take a fair bit of time before we have anything that is really concrete. In the meantime, I think implicit in the executive order is sort of the call to act, or the call to action that President Obama had in 2016. I think the hope is that certain state legislatures will look at this order and say, if we don't make changes, there may be a federal law in the future which would take away some of our ability to make our own changes. And certainly the argument always comes in, who knows better for the state, the federal law, the state law. That may cause certain states to react like it did previously, and I wouldn't be surprised if more states joined on.
Well, Andrew, I think that was all that we had time for today. I really appreciate you taking the time to speak with us.
Thank you. It's been my pleasure.